you all for coming back from lunch and for coming out. This morning we had two great panels. We had all about distributed manufacturing. We had all about the crazy, mind-blowing things that are happening in medical applications of 3D printing. And I hope all of you, or some of you, will stick around to see some of that in person at the reception that will be after the next couple panels over in Rayburn later on tonight. For the rest of the afternoon, just so everyone has schedules, had a chance to pick yours up, we'll be talking about intellectual property first, and then we'll get into growing small businesses. And as we've said a couple of different times, this is a place where new small innovators are coming in and really trying to blaze a path and do very interesting things. And so looking forward to that panel. And then we're going to wrap it up with education and 3D printing. And we've already seen the first two panels kind of allude to the importance of education and thinking of ways to integrate 3D printing into the classroom. And we have a great lineup of experts who really are doing education and 3D printing and can speak from experience about what works and what doesn't work and how it is working and not working on the ground. But with that, let me just welcome you back again to the intellectual property panel for 3D printing. We've got a great lineup of experts who are veterans of panels on intellectual property and 3D printing. They know all the answers to any question you could throw at them, so prepare your questions now. And we're going to talk about a number of things, but before we get into the questions, I want to let them all introduce themselves and talk about how they ended up, briefly kind of on the panel, what they're doing, what their background is, sort of, 2 or 3 minutes or so. Besides, they got an email from me begging them to come and be on the panel. So, why don't we start and we'll kind of go down the line.
Thanks, Michael.
Is it on?
Is it fun? Green means on. That's good to know. My name is Paul Banwatt. I am COO and General Counsel to a company from Canada called Matter and Form. I'm a lawyer. Before I was General Counsel of Matter and Form, I was an IP lawyer in Toronto. I also practiced in New York very briefly. And my interest in this area comes from a few different places. I have an alternate life as a musician that informs a lot of my positions on IP as well. And my company, we created a low-cost 3D scanner, and it's a copying device. It's a copying device that's very affordable to people, and it puts a new technology in the hands of people that they didn't have before. We're also creating a cloud solution called Cashew, which will let people host content online, like sites like Thingiverse and Sketchfab. And my big concern that I'd love to get into in this panel, I'll keep it brief right now, is how we're looking out for users of these technologies. I think companies like mine are relatively well positioned, but I don't know that users are educated enough or protected enough to be in this environment, play in this environment safely, and actually utilize the capabilities of these technologies.
My name is John Knapp. I'm the General Counsel of Solidoodle. We make consumer 3D printers. I was an IP lawyer practicing for about 10 years, representing various brand owners in consumer electronics, in fashion, and in gaming, electronic entertainment. And we've always had an interest in 3D printing, sort of being a tinkerer on the side, and brought in Solidoodle as a client about 2.5 years ago. And about a year ago came on as General Counsel. And what really interested me was a lot of my non-3D printing clients asking me, brand owners asking me, what is 3D printing? What should we be nervous about? And I thought that was the totally wrong instinct to approach such an amazing technology that offered so many opportunities. So what I'm really interested in is how 3D printing can be made easy and affordable and accessible to mainstream consumers.
I'm learning from you. I know that green is on. So my name is Tom Kurke. I'm one of the founders at a company called Source 3. Source 3 is a new company that we're focused on one thing, which is building a platform for the distribution and license of 3D content. A little background about Source 3 probably gives some context for my interest in this panel and the space generally. Source 3 is actually made up of two distinct groups of founders. One half of the founders come from developing businesses and solutions that know how to deliver licenses at scale. They built a business called RightsFlow, which serves the needs of several 100 million sound recordings. It's a company that was acquired by Google, and that business now serves as the transaction engine behind some of the YouTube licensing and monetization options. So we've got one half of the business and the founders that know how to build solutions at scale for licensed content. And the other half of the company, which I'm part of, comes from the 3D content ecosystem. So my background before Source 3, I was the president of a company called Geomagic. Geomagic is one of the leading suppliers of 3D capture and 3D interaction hardware and software solutions. So basically taking scan data, turning it into digital models, and then doing cool stuff with it. We were acquired by 3D Systems, one of the big 3D printing companies, in 2013. So obviously you can see a bunch of guys who are interested in licensing, a bunch of guys and people who are interested in 3D content acquisition and 3D printing, and that sort of speaks to the sort of penultimate thing, which is we believe there's a content opportunity in this space. We believe there's an opportunity for getting licensed content into this space, notwithstanding some of the current FUD that exists around some of the IP challenges. So I've been interested in the space for a while and excited to be here to talk to all of you.
So a lot of things that we can talk about, and a lot of things that we will talk about, but I want to kick it off with a question that, there are many people, there are people in this room who have various depths of IP knowledge. There are people who are using 3D printing who are coming from all sorts of backgrounds and have all different kind of paradigms of how they approach this stuff. In talking to people, both in your company and your users, what do you think is the biggest misconception that people have around IP and 3D printing right now?
I think probably the biggest misperception is that everything you print is subject to someone's rights. I mean, I think the reality is, and first, before I answer that question a little more, how many of you have, in this room, have read, seen, downloaded, consumed, whatever the white papers that public knowledge has made on these various IP topics? Okay, so I would suggest if you haven't, that Michael has authored a couple of really, really good background papers on intellectual property and 3D printing, running from licensing to just the basics, so I would suggest they're really a good starting point. But back to the question, I think the biggest misperception... Yeah, and now that I can take the plug off, the biggest misperception is that everything is impacted by somebody's rights. And clearly there's a whole class of items which are sculptural, creative element. There's lots of things that are, but many utilitarian and purely functional items, the kind of stuff that a lot of printers are used for, are not. And those can be freely shared and reproduced. So that, for me, that's probably the biggest thing I would say.
I would also endorse reading everything Michael's read. He says, gentlemen, everything Michael's read. I would say the misconception from a brand owner's perspective is that the 3D printing is just about counterfeiting. That's really the main. This is all kind of fluff around the hardcore of it, which is a bunch of Pirate Bay guys just scanning and making counterfeit copies of everything that's available. I think that it's just the wrong instinct, and part of what I'd like to talk about is that there are some glimmers of hope that the brands are not making the mistakes they've made with other new technologies, where they're just focusing on potential for misuse, and there is some glimmer of hope that they are focusing on the incredible opportunities that it presents for extending their brand, for engaging with their customers in ways that weren't possible before. But that is unfortunately still a minority, and the majority view is that this is just something that people are using to steal sales.
So I'm going to say something that hopefully is controversial enough that it'll make this panel really exciting, which is just to build on what, and I'm also going to echo that Michael's papers are extremely great to read if you're interested in the subject, but just to build on what Tom said, the idea that everything is protected somehow, I also think that to some degree we've done a disservice to users in the community by really pushing Creative Commons in a lot of these sites. I think the Creative Commons is an excellent tool. And what it does is it allows for copyrighted material to be shared, to be remixed, to be tweaked, to be used by lots of people, and then attribution to go back to the original author, and or prevention of commercial uses if that's what you want to do. But the problem is that sites encourage users who are uploading to pick a license, and they don't know what they're doing necessarily when they pick that license. And they often choose a Creative Commons license, and what that signals to the world is that there's this copyright that's being asserted on the object. And that's often not actually the case. So I think what we've done is we've created a monster in a way, and we need to take a big step back and start making the tools available for users to just say, I don't know if there's any rights on this object, or I commit any rights that might be in this object, I commit this object to the public domain, and make that the focus of what we're doing as much as possible. And then when we know there's rights, use solutions like what Tom's talking about to get users that stuff in a way that's really easy and transactional.
And along those lines, we're in a situation, obviously, I agree with you guys that we're in a situation where the assumption that everything has a right and a rights holder is problematic and potentially dangerous, but certainly problematic. Do you think, either in that context or in the larger context, does 3D printing, does additive manufacturing, does even digital manufacturing beyond 3D printing, does it create sort of fundamental fissures within IP law? Can IP law handle 3D printing? Is it something we need like a whole rewrite, or can we deal with the problems that we see with the existing IP law that we have?
I'll be the lawyer and say it depends. I think that what I would say is that reforms to IP need to be driven by IP-specific issues and not protections of markets, right? There's a lot of an instinct for someone with a control on the market with a really good business model that feels threatened by new technology is to fight it, and one of the tools that you'll often reach for is IP. And what is the IP around the space that we can use to keep a competitor at bay? And to the extent that they discover that there isn't an obvious answer in IP, or it would be very expensive to use the existing tools, that they clamor for more tools. Often without really thinking through the consequences. So as a general proposition, I would say I would urge caution in kind of clamoring for reform to IP, generally because the technology looks a little strange. When in fact, if you dig into it, there's a lot that's in our existing doctrine that is available, and that helps us deal with the unique issues. That said, there are certainly some unique territory being opened up by 3D printing. Something I'm sure we'll get into eventually is whether copyright has a safe harbor provision under the DMCA that allows for things like YouTube and user content to be on a website without subjecting that website host to liability, as long as they follow the safe harbor notice of takedown provisions. Are we at a point now where we're looking at a file that's not necessarily a movie or music that's subject to copyright, but also potentially an object that's potentially subject to patent, trademark, trade dress, trade secret, et cetera, these other types of intellectual property, right of publicity for that matter, that don't have a DMCA, don't have a safe harbor? Can a case be made to extend a safe harbor provision to those types of claims? I think that's something that we should explore. I think that an expansion of that brings with it the existing problems of DMCA. Fair harbor, fair use, for example, is sort of a victim in some ways of the takedown notice. That would be just exacerbated by extending the existing doctrine. And in some ways, when you're talking about a technology that allows for matching up and remixing and modifying, fair use is really, really, really important, maybe even more so than with music and movies. So to the extent that you're going to be sacrificing fair use protections, that requires some pause.
Yeah, so I think it's a great question, and I think people who, I think ourselves included when asked, fall in a range of responses from the current system works fine maybe with a few little tweaks, and then there's the other end of the spectrum, which is the sky's falling and we need to change it all because everything is new and we have to start from scratch. You know, I personally fall more towards I believe that our existing framework can be fixed to match the changing technology, more so than the throw it all out and start from scratch, because frankly the pace of technological change is so fast that if you start from scratch every time, you'd be starting from scratch all the time. You know, I would want to paint the picture for all of you in the room, though, to just sort of think through what the implications of what some of this technology will mean, because you know, we are in the not too distant future where what happened with the digitization of music and the ability to sort of make copies, you know, for a while the act of infringement was a very difficult thing. It was difficult to actually make a copy of a sound recording. You had to actually put a cassette in, do something. And then it became monumentally easier. And then the music industry had to deal with the digitization, and other industries had to deal with digitization. We're facing the exact same challenges in the world of physical goods over the next couple of years. Because in the next 2 years or less, the next laptop you buy will have a 3D scanner on it. So that means you will all be capturing 3D objects and 3D content, which means you will all be theoretically infringing, perhaps, if you happen to make a 3D capture of something that happens to be owned by someone else. And then as a brand will have to decide, are you an infringer, or are you somebody that we can possibly monetize? Or is there a way that we can work with you in the future? And so I think there are ways that the music industry learned painful lessons on perhaps what to do and not to do when their world became digitized that might be applicable in the world of physical goods when that happens. And it is happening, and it's around the corner.
Yeah, go ahead.
Just to add on to that, my own personal opinion is that dramatic overhauls of IP have been very difficult to accomplish, and when they are accomplished, it's not always for the best. But what is a little bit easier to do is create space. And so, back in Canada, for example, there was new space created a few years ago for user-generated works and remixes for non-commercial purposes, and that enables a lot of things to happen and allow people to feel safe within a space. And that just having that clarity of what is okay and what's allowed, that can be a lot easier to accomplish than dramatically changing the system. I think something similar in this case would make a lot of sense. You know, talking about the DMCA, it's great for service providers like my company, but it leaves users still relatively unprotected. So creating safe spaces for users would be really important. And if you're going to expand it to cover other areas because of these issues, I think creating safe spaces for users should be at the top of the list.
Yeah, and if you guys could build on that a little bit. I think that a lot of people talk about safe harbors in the context of 3D printing, both in terms of what users do, and then potentially, you know, safe harbors for trademarks, safe harbors for patent. Do you think that's a wise course? And if it is a potentially wise course, are there things that would need to be fundamentally changed in how we think about safe harbors to expand them, or is it as simple as just replacing the C in the DMCA with a T and a P and kind of going on with our day?
You're the warrior, you lead, so you're the real warrior of lunch.
As I alluded to, I think that, you know, one of the continued criticisms of DMCA is the way that a notice takedown regime works is, you know, puts fair use in a real difficult spot where you have content, you know, user uploads content that they believe is fair use and is fair use, let's say, but the would-be copyright owner that thinks it's infringing, serves the notice. And then the uploaders put in this difficult situation where if they counter notice, because they think because they have a good faith belief that it is fair use, it's sort of a game of chicken where if they do that, if they put the counter notice up, the company that thinks it's been infringed has to file suit. So you're you're inviting a lawsuit, and it's very expensive. And most users are not willing to take that risk, and so counter notices are quite uncommon. It's taking down the presumption that it was infringing, and that's it. So, you know, I often say fair use is the right to hire a lawyer, and often a little more. So, and that's already the case in, in copyright. When you get into objects where you've got derivative use, in CAD software where you can do add-ons and accessories and all manner of things that would be very well litigated by expensive law firms with really good arguments on both sides for a very long time to decide whether it was a fair use or not. Just for the average user, that's just not possible. And that can be a real deterrent to some of the creativity that we see and that we should be encouraging in the 3D space. So that is a concern of mine as far as simply extending the regime as it is to these other types of claims.
I just want to make it clear that the safe harbor under the DMCA is for service providers. I don't know if everyone knows that, but it's not for users. So you are still exposed, and I think that's really important to be aware of. And then in other areas of intellectual property, like trademark, I was reminded at the INTA event, the Tiffany eBay case, which basically said that if it comes to trademark infringement on a site, the service provider has to take a lot of the same steps as under the DMCA, or similar kinds of steps, appropriate action if they're given a notice of infringement. But there's not even a requirement for that counter notice in other areas. So a site like mine might not want to allow a user to have a counter notice and put something back up because we would be exposed to liability. So there is definitely needs for reform there, and then I'd say even more.
One of the things that happened as a result of the internet was that there was sort of a mass education in copyright. Everyday people began to understand copyright in a way that they had never had any interest or want or desire to before. And when we talk about the rights around 3D printed objects, we can talk about copyright attaching to files and not to objects, or objects not to files, how those pieces fit together, and then you mix in trademark, you mix in patent, you mix in right of publicity, you mix in all sorts of other layers of law. And so in the face of that, I have two questions. The first is it desirable to have a situation where people who are not lawyers, who are not in the industry, take this as an opportunity to learn all of those areas of law? And if yes, or even if no, what role do you think that the companies connected with 3D printing have in that, if yes, in that educational process? To what extent is it reasonable to expect people to understand all of those pieces?
Yeah, I think that's a great question. I mean, back to that sort of framework of the pace of technological change. The reality is that I think many people under the current statutory frameworks could be infringing, and certainly not be willful infringers, and certainly not even know that they theoretically have infringed someone's rights. So, I think as it relates to the companies involved in the broadly defined 3D ecosystem, and I would say in that ecosystem that includes companies that are involved on the 3D scanning and capture side. That would involve companies that are involved in the 3D modeling and manipulation side. That would be companies that are involved in the actual 3D printing side, the manufacturing side. It would be also companies that are involved in scanning large spaces, not just objects, because 3D is not just an object-based thing, it can be a scene-based thing. We all, I believe, share a mutual common, or should share a mutual common interest to make the purchasing public and the public aware as broadly as we can, without requiring them to become lawyers, as some broad metes and bounds that seem to be fair and safe. And then the other stuff that if it looks like it's not safe, maybe you need to go talk to somebody about it. Because I think in the end, that's the best practical advice. And then some way of statutorily protecting that if you fell into that first category and you ended up infringing anyway, that you're not going to be deemed a statutory infringer subject to statutory damages, or some other way to sort of draw that line. Because the other option is that everyone is potentially infringing, and then lawsuits take downs, and we're back to where we were 10 years ago, and we see how that all worked out. So I would suggest that there might be a better alternate for all of us to consider.
I would say that, I think there needs to be an educational process. I think it would be great if the public became a little savvier on these things and kind of knew their rights. And I think there's a lot of great organizations doing that work, some represented in this room. I think the real education should be for brand owners, and I think to the extent that there needs to be some changes in the law, it may be to disincentivize the kind of over policing, over enforcement that brands tend to think are necessary to protect their brands. There are some inherent doctrines in trademark and to a lesser extent in copyright that give brands a real incentive to kind of go after every infringement, and there's lots of lawyers purely altruistically that will tell you that it's necessary for you to sue everybody that you find to protect your brand. And you know, there's some incentives to do that. There's always the specter of losing control of your brand, of failure to police, you lose the mark altogether. And I think that there's some area for reform kind of within trademark doctrine in particular that I think would be useful, but I think education for the brands that that would help them understand better realistically what are the dangers that are out there that are explained not by the lawyers who are incentivized to make you really scared about it. That would be helpful.
And I want to point out one big difference in the current world we're in, which is that, you know, in the world of music and in traditional forms of copyright infringement, I think there was an assumption that you could fairly expect a person should know better, that they should know that a piece of music might have copyright associated with it, or that you know, a book that they're photocopying the entire contents of, it's probably not something you should be doing. I don't think you can make that assumption with the kinds of objects we're talking about right now. There's a case in front of the Ninth Circuit Court of Appeals right now. It's a copyright case that's asking the question of whether the Batmobile is a character or not, and therefore copyrightable. Like, the average person is not going to be able to conduct this analysis with physical objects. And because of that, and because of the fact that, you know, trademark and patent law aren't even set up that way in the first place, there was an assumption that, you know, the people who would be infringing would probably be companies, and it would be commercial infringement. So we need to rethink this and really care about whether it's a willful infringement, whether it's a commercial use, and carve out those non-willful, non-commercial infringements that users are going to end up, you know, doing. And that's where I'm going to go back to my big message: is safe spaces are what we need to create from a policy perspective.
Yeah, and I want to sort of briefly take off, and I'll make the announcement I made earlier, which is for those of you who don't spend a lot of time in congressional office buildings, the buzzing is not an alarm. It's for things happening on the floor and votes and whatnot, so feel free to ignore it. And yeah, I think that a bad solution to all of this is to train people to just always assume there's a rights holder and always assume they need permission, because that really just throws sand in the gears of innovation and creativity. It's a very expensive way to train people incorrectly as to how the law works. But that being said, there's a whole stew of rights and potential rights holders, potential infringers, potential users floating around. Right now, you know, as of today in this world, even if people haven't found the answer, what are the kind of things you look to as encouraging signs, as green shoots, if nothing else, of rights holders, companies, users coming together and really trying to do different than we saw in the music industry version of this? What are the encouraging signs in this space right now?
Yeah, so I think there are encouraging signs. I think the panel we heard speaking before lunch, and just talking about the ability to sort of have open source models around some of the NIH models, some of the prosthetics. Those are, I think, sort of examples of, you know, community sharing of results in the betterment for everybody, the sharing of those models, and open type licensing models to allow people to create derivatives. So that's great from a sort of policy and non-commercial side. But then putting on my hat for my company, you know, a great example of I think of a smart brand entity that's sort of, I think, a good representative use case of how things can be done is you know, one of the major toy manufacturers, Hasbro, licensed some of their works, this My Little Pony, this design, allowed a couple of designers to create licensed derivative works of those works, and then sold them to superfans through a site called Shapeways. And why do I like that model? I like that model because here's a brand who had a choice. Superfans have been creating derivatives of their My Little Ponies all the time, posting them on share sites. They would be infringing, and the brand could either choose those individuals and deem them to be infringers, or to view them, quite frankly, as a monetization opportunity, and to find a way to pursue a revenue opportunity that was consistent with their brand, and to not be a perceived bad actor of a notice and takedown. Without flowing, a lot of the economics of that model are public, but to just sort of paint the picture, my guess would be that for every one of those My Little Ponies that gets produced that way, Hasbro probably makes 50 to 100 times what they make through retail distribution. Once you sell a non-personalized item going through regular. So obviously the brand wins, the artists win, they get licensed works, the consumer gets what they want. And so I would point to that as one example of the way things can work.
Yeah, absolutely. I think there's that example. There's the GoPro has been really interesting. They've been sponsoring accessory design contests, where this could clearly be something that they were going after aggressively, and instead they're supporting. Legos, would be right in the crosshairs of this. With ABS is the plastic that Legos are made out of, that the printers are actually using. They've been some mixed messages, but generally really supportive. And you see a lot of brands kind of embracing it. I think that and the Shapeways example is fantastic. Compared to, for example, the way the movie industry reacted to home video recorders at first, and fought it, and then realized that home video market was potentially a bigger market than the theaters and tickets. The way the movie industry famously fought peer-to-peer and sued college kids until they got religion and figured out a way to embrace it and turn it into a consumer crowd. It seems like the hope is that we're skipping over that interim litigation phase, and we're finding some really progressive brands finding ways to embrace this new technology, acknowledging that there'll be infringement, but not focusing and not letting that color their view of the opportunity.
Yeah, I mean, I would just add one more example. Nokia was one of the first companies that started doing this as well, releasing the designs for or allowing people to basically remix the designs for the shells of their phones. And I mean, you can contrast that approach with some of the companies out there who, obviously on the advice of their lawyers, are issuing as many DMCA notices to people as possible as soon as they find examples of their work. And I think you're either creating a community on the one hand, or you're creating a group of really upset, disenfranchised people who were probably fans of yours prior to that, because that's why they were out there doing this in the first place.
So I want to open this to the floor in a moment, but I want to ask you one last question, because we're here in Washington, so I want to ask a policy question, a legal question. If you were king of the United States, and the citizenship issues aside, for the day, and your only power was to make one change in the law related to 3D printing and IP, which would be a great opportunity, of course, what would you focus on? Even if you don't have a concrete answer, where would you look at and say, this is where my magic power would be best exercised first?
Well, I'll keep it simple because I think I've been saying it the whole time. But Ted Cruz was born in Canada, so you never know what could happen. Yeah, I mean, again, I think that the key has to be safe spaces for users. That's where we need to focus our attention. We have to make it very clear to people who want to engage in this area, who want to engage with 3D technologies, who want to scan stuff, who want to use ZBrush, or use whatever modeling program they want to use, who want to print stuff out with 3D printers, who want to send files to their friends across the country, who want to play in maker spaces. All of this stuff, the guy who asked the question who has a 3D hub, you don't want people scared off because they don't know whether what they're doing is okay. So let's make it safe for people to do this, at least if it's non-commercial, at least if they don't know that they're infringing anything. And I think you can put that much responsibility on a rights holder, at least.
Yeah, it's a tough one. I guess I would say concentrate on removing the incentive for brands to overreach and kind of squash creativity because they are afraid they're going to lose their valuable assets. You know, the naked licensing doctrine, the failure to prosecute, where they're afraid if they don't go after these new uses, they're gonna lose this valuable asset. Make it okay for them to sit back and see their creative uses happen and see their customers engage with their brands in imaginative ways, and let them be kind of inspired by that and figure out models, and let that just give room to breathe without feeling that they're going to lose something valuable. And the takedowns will go away, the lawsuits will go away, and that space will be created by disincentivizing the overreach.
Yeah, I would fall into the camp of the safe space concept. I think the pace of change is so quick, and these technologies are potentially so incredibly impressive. If you haven't seen, I mean, what you can do with some of the new tech, I think it's very hard to see or to burden an individual consumer with a statutory infringement obligation for doing things that they would have no reasonable expectation or belief would be infringing. And I mean, I don't know how, you know, I'd leave it to far smarter people in the room than me. I think you'd be a good guy to sort of figure some of this out. I think we need to think about that, because as an industry, the choices are we can either continue to spin wheels and wasting precious cycles around edge cases which technically might be infringing but really are not an economic cost to manufacturers or brands, or we can focus on providing clear guidance for things that, you know what, are infringing and really do represent a lost cost, and find out ways to make sure that those activities are punished or monetized and the other ones aren't.
You guys are all invited back next year. So yeah, I want to open up the questions, but I want to kind of follow on that, is that one of the important things is when you're thinking about 3D printing, especially from a legal policy standpoint, 3D printing is a gateway drug in a lot of ways to digital manufacturing. Especially when you start doing 3D printing and you realize, I think we'll talk about this earlier, it's one tool in the arsenal, it's the microwave. And when you start seeing the other digital manufacturing tools, the laser cutters, the CNC routers, which conceptually are very similar in the sense that you have a digital file for a physical thing, you can download it on the internet. And so when we think about next stages of the economy or next stages of parts of the economy and creating safe spaces for ostensibly for 3D printing, or that start with 3D printing, we're really talking about something more complex and about creating space for a digital manufacturing economy to take off in a way that includes 3D printing, but is certainly not restricted to 3D printing. But with that, I want to open the floor to questions. If people have questions, I will repeat, as I always repeat, that in Washington and elsewhere, questions end with a question mark and not a period, so please try and make your questions actually questions. But if you have questions, raise your hand and you can ask them. Do not be afraid of asking questions. All right.
Is there anything that could be done to like make this a more pressing issue, to like convince the people who can eventually like, you're all making it sound like this isn't really settled yet. What can we do to convince the people who decide to settle it without waiting for there to be a crisis? Anything? Nothing?
The idea of having statutory reform is, it just, you know, unfortunately it's so remote. And the kind of perverted kind of view of this is that in some of these things won't be sorted out as a lawsuit, and that's an awful thing to hope for. But in some ways, you know, there won't be certainty until, you know, the courts weigh in, and it's unfortunate, but that's how these things actually will shake out. And that's the quickest way to certainty, unfortunately.
Yeah, I mean, I think that is probably true, but I mean, I think there is a vehicle, though, for a potential change with, you know, the government is investing heavily in additive manufacturing through NAMI/America Makes, various R&D initiatives, various funding sources. I mean, I think it doesn't take a panel of us up here and all of you to realize that intellectual property issues are one of a cast of things that can slow down additive manufacturing as being one of the manufacturing techniques that can sort of support this personalized economy. So perhaps there's an opportunity through through the American Makes and through this figuring out how to work with sub-suppliers in an industrial environment that helps kickstart some of this. You know, I think putting on the skeptic's head, though, I think change often comes from litigation, and perhaps that's where some of this will come as well.
I'm going to take a slightly more optimistic tone. Maybe it's because I'm from Canada. I will say that there is a massive community of like-minded people here who want the same things. And they come from a lot of different places, and I think that there's an opportunity there to create conversation. I think Michael's done a really good job of doing that at public knowledge, but I think the more that's written about this, and the more that I'll plug my blog right now, Law in the Making, if you want to come check it out.
Great blog.
Thank you. But the more that's written about this stuff, and the more that is discussed in communities, and the more that this becomes an issue that we are all talking about, I think the more likely it is that the change that needs to happen happens before grandma gets sued or whatever terrible thing happens that causes people to actually take notice otherwise.
It is nice, in the UK right now, there is a process that they're going through about IP and copyright reform that is geared towards a non-crisis oriented method of change. And this morning there was a hearing about copyright reform. There is a process that's going on in the House, but I think, especially domestically, it is a process, and it will be a process for a while. Other questions? I know there was one in the back.
The file formats that are out for 3D printing right now aren't really conducive to DRM or serialization or anything like that. Who do you see is addressing that problem? Is there any action happening at a government level? Are there going to be open or closed standards? Do you have any opinions?
Yeah. So I can take a crack at that. So, the most common file format for 3D printing is really it's a legacy 20-year-old file format. It can be as dumb as ASCII code to help make the items that get produced. There have been various attempts to introduce new file formats. There's the AMF file format, which is this advanced manufacturing specification file format, which was pushed as a standard to sort of make technical improvements in the way the file can be used to produce items. Microsoft has thrown their hat into the ring saying that they're going to come up with a new file structure and file format to support additive manufacturing as part of Windows print drivers. But I think none of them have done some of the basic things, which, like, even in the MP3 world. In the MP3 world, there's this concept of this metadata that you can stick along with an MP3 file, which has things like title, track, like very basic information about the file, which would be useful for rights holders and others if that information were in the file. Because then it'd be easier to know whether or not the file you had was infringing legitimate, should you have it or not. And that really hasn't been a focus of a lot of the standardization or a lot of the specification work. But I think it will be in coming years. And I would suspect Microsoft, I haven't seen the format, but I would suspect Microsoft will try and support some of that. And I believe Shapeways actually has their own file format as well, but I don't believe also that that has a focus on intellectual property issues in the file format changes.
Another question here.
And so I hear a lot around the IP of actual CAD models and the end-use parts. It seems like distribution of models is actually going to be done mainly through G-code, which is just how it is with any computer numeric controlled machine, which 3D printers fall under. Are there complexities with that being a distribution model and streaming through G-code, since you could have, even though the end-use part looks the same and the CAD model looks the same, you could have hundreds of versions of that G-code depending on what you're manufacturing on? Are there complexities there as far as protecting that?
Yeah, you want to? Yes.
Easy answer.
Yeah, I know there's been proposals for various kind of DRM approaches. It just I don't see it happening. There's just kind of too many steps along the process. It just doesn't seem viable. But maybe I'll be proven wrong, at least within the current environment.
Time for one more question, if there is one more question. If not, then I will say thank you to the panel, and we will take 5-minute break. The next panel is about growing small businesses. It will be followed by integrating 3D printing into the classroom. The next panel will start at 2:30. Thank you all.